What happens when two companies merge and the CEO walks away with millions? What legal duties do directors owe when negotiating a high stakes acquisition? In today's advanced lesson, we'll enter the world of corporate law, where millions are at stake. Strategy is critical, and lawyers play a key role in shaping business decisions. You'll learn how to explain corporate transactions like mergers and acquisitions, understanding fiduciary obligations, and use complex legal grammar like conditionals and the passive causative, all with the clarity and precision expected in boardrooms and corporate filings. This is part of our full legal English course for lawyers and professionals. For full lessons, live practice, and expert support, join our school community. The link is in the description. In today's class, you'll strengthen your ability to talk about corporate law, especially when advising clients involved in business deals or internal governance. We'll focus on three essential corporate terms: merger, acquisition, and fiduciary duty. Then we'll build your grammar with two advanced tools: legal conditionals to describe risks, strategy, and consequences, and the passive causative to explain what companies had done, often by others, like the board had the report revised before the vote. This lesson prepares you to speak with confidence in negotiations, due diligence, or corporate advisory settings. Before we begin, let's take a moment to reflect. What do you think of when you hear corporate law? Perhaps you picture mergers and acquisitions, complex deals where companies combine resources or expand their markets. You might think of internal investigations to fraud or insider trading, or the scrutiny around executive compensation, especially when public trust is at stake. Corporate law touches everything from regulatory compliance and strategic decision making to shareholder disputes and fiduciary responsibility. It's about managing legal risk, enforcing duties, and protecting both the company and its stakeholders. Let's now look at three ideas you'll return to throughout this lesson. I'll give the first part and finish each one with a real world example. One risk in a merger is losing key talent if executives aren't retained under the new leadership. If a director fails to disclose a conflict of interest, then the board's decision could be challenged or invalidated for breach of duty. Fiduciary duties exist to ensure that directors act in the best interest of the company, not for personal gain or outside influence. Keep these scenarios in mind. We'll connect them to our vocabulary, grammar, and legal reasoning in the slides ahead. Merger. In 2021, two regional telecom giants announced they were joining forces. Instead of one acquiring the other, they agreed to a merger, forming a single unified company under a new name and structure. For example, the merger created the largest telecom provider in the region. Mergers are often presented as partnerships, but behind the scenes, they involve intense negotiation, regulatory approval, and complex restructuring. For legal professionals, clarity around voting rights, shareholder impact, and asset transfer is critical. Acquisitions. Acquisitions happen when one company buys another, often to gain talent, technology, or market share. In a recent deal, a major tech firm acquired an AI startup for $250 million. Overnight, the buyer gained exclusive rights to a powerful algorithm. For example, the tech giant's acquisition of the startup raised antitrust concerns. Unlike mergers, acquisitions don't always involve equality, and sometimes the acquired company disappears entirely. For lawyers, acquisitions require careful review of contracts, liabilities, and post transaction obligations. This one is a tongue twister: fiduciary duty. In a high-profile case, a board of directors approved the sale of the company without disclosing that a better offer had been received. Shareholders sued, claiming a breach of fiduciary duty. For example, the board breached its fiduciary duty by failing to disclose material risks. Fiduciary duties like loyalty, care, and disclosure are the backbone of corporate trust. When breached, they open the door to liability, reputational damage, and shareholder revolt. Corporate lawyers must ensure directors understand these duties and document how they fulfilled them. Due diligence. Imagine this. Your client is about to buy a logistics company. Everything looks good on paper until your team starts due diligence. You discover unpaid taxes, hidden liabilities, and employment disputes. The acquisition was delayed after due diligence revealed unresolved tax issues. Due diligence protects clients from walking into legal traps. It involves reviewing contracts, debts, compliance records, and litigation history. For lawyers, it's not just a formality, it's the firewall between strategy and catastrophe. Hostile takeover. Not all acquisitions are friendly. In a hostile takeover, the acquiring company bypasses the target's board and goes straight to shareholders, often by offering to buy shares directly or replacing the board. For example, the company launched a hostile takeover after its offer was rejected. These cases are aggressive, high stakes, and often play out in public markets. Lawyers on both sides must act quickly, filing disclosures, triggering poison pill defenses, or negotiating under pressure. Indemnification. During a shareholder lawsuit, the CEO asks a key question. If I'm personally sued, will the company protect me? That protection often comes from an indemnification clause, a promise that the company will cover legal fees or damages as long as the executive acted lawfully. For example, the contract included an indemnification clause for all board members. These clauses are common in corporate bylaws, merger agreements, and executive contracts. For lawyers, it's essential to draft them carefully. They protect decision makers, but must also balance fairness, cost, and corporate responsibility. Now, let's do a word bank challenge. We are going to test your corporate law vocabulary with a scenario from board governance. Picture this. The board approves a deal that benefits one director personally, but leaves out key disclosures to shareholders. Litigation follows. What is the legal duty that requires directors to act in the company's best interest? That's called a fiduciary duty, a duty of loyalty, care, and disclosure. For example, the board breached its fiduciary duty by failing to disclose material risks. This concept is essential in any discussion of corporate integrity and leadership accountability. Next one. You are advising a senior executive who's being sued for actions taken during her time on the board. She acted lawfully, but the lawsuit is expensive. What is the term for a company's promise to protect that person from personal legal liability? That's indemnification, a clause that ensures directors and officers are compensated for losses if they acted in good faith. For example, the contract included an indemnification clause for all members. This term is a key part of risk management for corporate leadership. Now, a company wants to take over a competitor. The board of the target company rejects the offer, but the acquirer goes directly to the shareholders with the public bid. What's the name for an acquisition attempt made without board approval? That's called a hostile takeover, and it usually involves rapid legal responses, shareholder influence tactics, and takeover defenses. An example, the company launched a hostile takeover after its offer was rejected. Imagine this. Two equal-sized companies see an opportunity to join forces and create a stronger market presence. They agree to form a new legal entity and operate under a single structure. What's the term for when two companies combine into one new legal entity? That's a merger, a legal and financial integration of two businesses. Like we talked about before in the example, the merger created the largest telecom provider in the region. On to another one. You are advising a client on buying a software company. Before the deal closes, your team begins reviewing contracts, tax records, and pending litigation. What's the name for the legal and financial review process done before a transaction? That is due diligence, the process that protects buyers from hidden liabilities and ensures informed decision making. For example, the acquisition was delayed after due diligence revealed unresolved tax issues. Now, a multinational wants to expand into Latin America. Instead of building a new operation, they purchase an established local company. What do we call it when one company buys another to gain control? That's an acquisition, where one business absorbs another's assets, brand, or operations. For example, the tech giant's acquisition of the startup raised antitrust concerns. Now, let's look at how lawyers use conditionals to explain legal outcomes, both real and hypothetical. If the board approves the deal, the merger will proceed. This is a first conditional. You're predicting a likely future event. Approval leads to execution. This is common when advising on expected next steps. Let's move on to another one. If the company disclosed the risks, investors would be reassured. This second conditional talks about a current situation that is not true, the company didn't disclose, so investors are nervous. This helps you suggest improvements or assess what could have been done differently. Let's go to another one. If we had completed due diligence, we would have avoided liability. Now we're using the third conditional. It's used for reflection, often in post-mortem discussions after a transaction has gone wrong. It expresses regret or a missed legal safeguard. Mastering legal conditionals help you communicate risk, responsibility, and consequences clearly in contracts, in memos, and client conversations. Now I want to put your legal conditionals into practice with a real-world case. The company completed an acquisition, but skipped over parts of due diligence. After the deal closed, financial and regulatory problems surfaced. Now the board is under pressure. We'll use conditionals to analyze the situation from different angles. If the board had reviewed the compliance report, it would have flagged the red flags earlier. That's a third conditional. It reflects on what went wrong in the past and how it could have been avoided. If the press continues reporting, the company will face reputational damage. This is a first conditional, a prediction based on an ongoing situation. If the directors were more transparent now, investors would be more cooperative. This is a second conditional. It imagines a different present and how it would affect behavior. Conditionals like these help you explain legal risk, give strategic advice, and show clients the consequences of past and present decisions, clearly and professionally. In corporate legal settings, executives and boards rarely do everything themselves. They delegate. And when describing that delegation, lawyers often use the passive causative. For example, the board had the agreement reviewed by external counsel. The board didn't review it personally, they arranged for someone else to do it. The action is caused, not performed. We got the financial statements audited before the annual meeting. This is often used when discussing compliance. Something required was completed, but by a professional or a third party. The CEO had the press release drafted before the merger announcement. This shows preparation and strategic communication, even though the CEO didn't write it herself. The passive causative is especially useful in legal writing, reports, and negotiations when describing what actions were taken and by whom in a formal, indirect, and professional way. Let's apply the passive causative to a real world merger scenario. The board is finalizing a deal. They didn't draft, audit, or announce everything themselves, but they made sure it all happened. Instead of saying, external lawyers reviewed the transaction documents, we say the board had the transaction documents reviewed by external lawyers. This highlights delegation and legal formality. The accounting firm did the audit, not the company. So we say they got the financial statements audited before the deal. That phrasing shows responsibility, not direct action. Another one, the CEO didn't write the press release, but made sure it was ready. So we say the CEO had the press release drafted in advance of the announcement. This grammar structure is essential when explaining how decisions are executed in high level corporate environments, where responsibility doesn't always mean personal involvement. Now, my favorite part, idioms. Put something on the table. In high stakes negotiations or boardroom strategy, someone eventually needs to put something on the table. Let's take a real scenario. A publicly traded company is facing a hostile takeover. The share price has dropped, investor confidence is low, and the board is divided. During an emergency session, the general counsel steps in with a bold proposal, a stock buyback to stabilize control and signal strength to the market. For example, the general counsel put a stock buyback plan on the table during the board's emergency session. This idiom captures the moment when an idea becomes official, no longer theory, but a concrete option for decision makers to act on. It's direct, proactive, and shows legal leadership. Whether you're negotiating a settlement or proposing a restructuring plan, when you put something on the table, you shift the dynamic and invite others to respond. The ball is in their court. In litigation and corporate negotiations, timing is everything, especially when responsibility shifts from one party to the other. Imagine this. After weeks of back and forth, your legal team finalizes a revised settlement. It's detailed, realistic, and well within the negotiation framework. You send it off before the weekend, ensuring their legal counsel has time to review. On Monday, a junior associate asks, "What's our next move?" You answer with confidence, "We delivered the final settlement draft last Friday. The ball is in their court now." This idiom is perfect for legal profession. It communicates clearly that your side has acted, and now it's time for the other party to respond. And it's their duty to respond, accept, or reject, or counter. It also serves as a subtle pressure tool by stating that the ball is in their court. You frame the silence as their delay, not yours. A double-edged sword. Corporate strategy often involves trade-offs, and sometimes what seems like a win brings hidden costs. Picture this. A multinational firm acquires a promising fintech startup. On paper, it's a brilliant move. They gain immediate entry into new markets, new clients, and a wave of innovation. But soon the problems surface. Legacy systems are incompatible, the startup's culture clashes with the parent company's risk protocols, staff turnover rises, millions are spent on integration. The client calls you in for advice, and you summarize the situation with one phrase. It was a double-edged sword. In law and business, this idiom highlights decisions that carry risks on both sides. A merger, a publicity campaign, even filing a lawsuit. Each may offer benefits, but also expose vulnerabilities. Using this phrase shows strategic thinking. It signals to your client that you're not just a technician, you're a risk aware advisor. In the driver's seat. In corporate law, leverage is everything. And the moment a party gains decisive control, they are in the driver's seat. Consider this situation. A private equity investor quietly increases their shareholding in a family owned logistics company. At first, they're a silent partner, but after crossing the 70% ownership threshold, the dynamics shift. They appoint new board members, influence hiring decisions, and start restructuring operations. Now, when decisions are made, they don't just participate, they lead. Example, after acquiring 70% of the shares, the investor was firmly in the driver's seat. This idiom is powerful in legal and business storytelling. It explains not just who is involved, but who controls the outcome. Being in the driver's seat means setting the pace, steering the process, and when necessary, applying the brakes. It's especially useful when advising clients on what kind of leverage they have or don't have. Bury the hatchet. Corporate conflicts can stretch for years, draining resources, damaging reputations, and paralyzing decision making. Here's one example. Two co founders of a successful tech company split over strategy. One backs aggressive expansion, and the other wants to consolidate. The disagreement escalates. Lawsuits are filed, voting rights challenged, and public statements turn hostile. Investors grow anxious. Eventually, both sides realize the cost is too high. They agree to mediation. A confidential buyout is arranged. Control is restructured, and the remaining founder issues a joint press release acknowledging past differences and now a shared vision for the future. So the example is this. After years of shareholder litigation, the two founders finally buried the hatchet in a private settlement. This idiom goes beyond legal resolution. It's about emotional closure. In corporate law, where egos and histories can be as important as facts and figures, helping parties bury the hatchet can be the most valuable service you provide. It signals a fresh start and your ability as counsel to guide parties out of conflict and toward renewed cooperation. Rock the boat. In corporate settings, especially during sensitive transitions, maintaining stability is often more valuable than winning an argument. Take this example. A company is preparing for its IPO. Internal audits reveal minor irregularities in reporting, nothing fraudulent, but enough to raise eyebrows. The CFO is defensive and wants to contest the report publicly. The compliance officer advises caution. She warns rejecting the audit findings would rock the boat before the IPO. This idiom highlights how a single disruptive act, even if justified, can upset delicate negotiations, public perception, or investor confidence. In legal strategy, you must help your client choose their battles. Sometimes the smartest move is to stay quiet, fix the issue internally, and preserve momentum. Other times, rocking the boat is necessary, but the consequences must be anticipated. When you use this phrase, you're signaling both risk awareness and strategic restraint, two hallmarks of excellent corporate counsel. Now, I want us to bring everything together with a story that could be straight from a corporate law textbook or a real life boardroom. Now, Company a regional logistics powerhouse, quietly acquired a direct competitor. The deal was swift and controversial. It wasn't just a merger, it was a power play. Minority shareholders who hadn't been consulted raised questions about fiduciary duty. Had the board truly acted in the best interest of all shareholders? Or had key players engineered the acquisition for personal gain? In response, the general counsel put a settlement proposal on the table, restructuring the board to include independent oversight and offering compensation to dissenting investors. But the lead investor was now in the driver's seat. With controlling shares, they had the final say. Still, one director threatened to rock the boat by leaking sensitive internal emails to regulators. The pressure mounted. After a tense weekend, the founders met privately and buried the hatchet. They agreed to appoint a new compliance officer and expand disclosure obligations moving forward. Throughout the negotiations, legal language carried the strategy. If the board had disclosed the conflict earlier, we would have avoided this backlash. Third conditional. By the time we announce the vote, all objections will have been addressed. Future perfect. The merger must be approved by the regulatory authority before implementation. Passive causative. This is the real world of corporate law. High stakes decisions, layered strategy, and language that builds trust, clarity, and control. Let's take a moment to review what you learned in today's lesson on advanced corporate law topics. First, we expanded your legal English vocabulary. You now have strong, precise terms to talk about corporate structures, risk, and decision making, including fiduciary duty and board resolution. Second, we practice advanced grammar, using legal conditionals to show consequences, passive causatives to describe responsibility, and the future perfect to forecast outcomes clearly. Third, we put that all into action, using these tools to explain legal advice, predict timelines, and make professional recommendations to clients. And finally, you learned how to elevate your communication with idioms like rock the boat or in the driver's seat, phrases that make your legal advice more human, relatable, and strategic. Want to keep going? Join us in our school community for full course access, legal practice groups, and expert feedback. The link is in the description. We will see you there.